What do you mean by that? Is the right thing about what? Calling Ted Cruz out? Yes.
Voting for Colin
Good morning, everyone. We'll be getting started here shortly. I was doing one quick captions check for YouTube. Microphone check, 1, 2, 3. Captions check, 1, 2, 3. Thank you for those joining us online. Kind reminder for those in the room, if you're going to speak today, please make sure that the light is on the microphone before you do so. And after you are done, please make sure that you mute the microphone before you leave, as I'm about to do right now.
Senator Royce, can you hear? Can you?
It's Royce, R-O-Y-C, not Roy.
Okay, thank you so much.
Good morning, everyone. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Friday, October 25, 2024. The time is 9:30 a.m. We're joined today by Commissioners Bobby Janeka and Katarina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. Registration has now closed, but if you'd like to address the Commission, we'd ask you to please visit our registration table or email agenda@tceq.texas.gov. Identify yourself, include the item that you'd like to speak to, and also identify any affiliation that you have. We'll do our best to accommodate that request. For those who are addressing the Commission, our General Counsel or I will let you know when it's your turn and we'll inform you of your time limits. We appreciate everyone being present today. We are going to take items a little bit out of order this morning to accommodate our State Senator Royce West. And Ms. Smith, I'll ask you to please call the first item.
Item 3 is the consideration of an application by Texas Star Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 171636. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record. As a courtesy to legislators and statewide elected officials, the commission allows officials to address the commission at agenda meetings. As a reminder, the commission may only consider the administrative record, which includes the parties' filings, the draft permit application, and the ED's response to comment when making their decision today. But with that, we'll begin with Senator West.
Good morning, Senator.
Can you hear me?
We hear you now. Yes, sir. Thank you for being with us.
My pleasure. I wish I could be there in person, but I'm trying to get ready for trial next week, so I'd be there otherwise. And I want to say good morning to each and every one of you, and also to you, Mr. Chairman, and to the Executive Director, Kelly Keel. For the record, my name is Royce West. I represent the citizens of Dallas County and Senate District 23. I'm speaking to you today in my capacity as a state senator for the Texas State Senate District, in which Joppa resides. It's a Freedmentown community located in the southern sector of Dallas. And I appreciate and understand that you have to look at the record. That's exactly what I'm going to ask you to do. Take a look at the record that is before you. I'm here this morning to stand in support of Joppa, which is represented by the Joppa Freedom Town Association, its opposition to the approval of the new application for the concrete batch plant standard permit. Now, I'm not going to say that I have all the experience in the world about batch plant permits, but I do know a little bit about it. It is the community's belief that the applicant, the Texas Star Ready Mix LLC, has not operated in good faith with the authorities. It has committed numerous violations and has not acted in the best interest of the community in general. The Joppa community disagrees with the executive director's decision to approve the standard batch plant permit application submitted by the Texas Star Ready Mix. Furthermore, the community disagrees with the executive director's decision to deny the association's request for reconsideration of the director's decision. I became involved from a historical perspective. I became involved in this matter when the community and TCEQ came together, and frankly, I received a last-minute notice of a public hearing held by TCEQ at a hotel here in Dallas. I believe that was like on August the 17th, 2023. I was informed this meeting took place at the request of my colleague, the Honorable Representative Tony Rose, and others. Among the elected officials representing the citizens of Dallas and Dallas County, I'm not alone in supporting the community's opposition to this application submitted by Texas Star Ready Mix. Letters opposing the permit have been submitted by State Representatives Vinton Jones, Dallas City Councilman Tanel Atkins, and Adam Bazadula. Now, I understand and appreciate that you, when you consider these types of permits, you probably get opposition letters from all over the state, depending upon where it is and what it's doing, and I appreciate that. However, following the public meeting in which a representative of Texas Star Ready Mix stated publicly that the plant had operated without the required permit. Let me say that again. A representative of Texas Star Ready Mix stated publicly that the plant had operated without the required permits. I had several meetings either by conference call or virtually with the interim executive director at the time, now director, to discuss the process and the agency's activities regarding this Texas Star Ready Mix. And I think it's a part of the record. It should be if it's not. Since that time, my staff has continued to monitor both the application and the enforcement action levied against this plant. Mind you, it was not operating with a permit. The first agreed order was issued by TCEQ on September the 7th, 2023. The second order was negotiated and issued by TCEQ, I believe, on November the 10th, 2023. Subsequently, the agreed order was signed by Texas Star Ready Mix on June the 5th, 2024, on behalf of the executive director on the 6th of June, 2024, and by the commission on July 23rd, 2024, thus becoming effective. In the agreed order, it's alleged by TCEQ that during the investigation on September the 12th, 2022, and August the 29th, 2023, the respondent operated a concrete batch plant prior to obtaining the proper authorization. Let that sink in. They operated the plant without getting the proper authorization. Anyone in that business knows that you got to have the proper authorization in order to operate a plant. The question is whether or not this action or lack of action was because of where the plant is located. Later, it was determined that the plant operated without authorization as early as July 23rd, 2022. It's unclear, not explained why an inspection that took place on August the 29th, 2023, again cited the plant for operating without a permit when Texas Star Ready Mix claimed that it ceased operation on August the 9th, 2023. So why are you citing them subsequent to that particular date where they said they had stopped operating? Makes no sense at all. Bad fact. On August 31st, my office received information on other violations that were pending enforcement actions. In addition to operating without authorization, they included citations for distant requirements and violations, citations for an open conveyor system. I'm not aware of the outcome of these two additional violations, but I do want to know what the outcome actually is. However, during the August 17th public meeting, TCEQ staff stated that enforcement action for alleged violations are processed separately and independent of the permitting application. I'll revisit this assertion by TCEQ, which frankly makes no sense to me if indeed you're looking at whether or not an applicant should get a permit. We are looking at have two separate processes that never come together, and we probably need to talk about that. Other parties have joined in sharing their concerns or opposition to the approval of this particular application. I think on July 22nd, 2024, a letter was issued from the Environmental Protection Agency who expressed the concerns that the facility was operating as a concrete batch plant improperly under a permit by rule PBR for bulk minerals handling. I don't know what that is. I know that they're saying that they were operating improperly under that particular permit. In a memo to my office, TCEQ said it had the discretion to reduce penalty amounts because Texas Star Ready permit had another TCEQ permit, a permit of rule registration. However, what I would like to clarify at a later time is whether the PBR was a permit held by a previous operator or by Texas Star Ready Mix. The EPA further states the facility does not appear to meet all the requirements of the standard permit, citing aggregate loading within 50 feet of the property line, not utilizing dust suppressing fencing or other equivalent barriers at the height of at least 12 feet. And in addition, the suction shroud, fabric cartridge filter, exhaust, and storage silos appear to be located less than 100 feet from the property line. I want you to think about that. Those things are supposed to be, by rule, I believe, complied with. While acknowledging that only one JAPA resident meets the qualification of an affected person, the EPA strongly encouraged TCEQ to consider that there may be a public interest consideration for granting a hearing due to the presence of green spaces within the Trinity River Corridor, and I know many of you know about the Trinity River Corridor, and the frequent use by JAPA residents of this particular area. The EPA requested that prior to issuance, TCEQ, via an inspection of the facility, ensure that the existing equipment, stockpiles, and vehicles operating areas satisfy the setback requirements as stipulated in the concrete batch plant standard permit. The agency also wrote that TCEQ decides, if you decide to issue the permit, that it should be considered, that you should consider all requests it received from the community for the contested case hearing. The Office of Public Interest Counsel also recommends that the Commission grant JAPA's request for reconsideration of the Executive Director's decision to approve that permit application, or that you grant a hearing based on public interest pursuant to the Texas Water Code. In making its recommendation, OPIC noted that TCEQ is required to review a plant's compliance history. In doing so, TCEQ is required under the Administrative Code to review enforcement orders and investigations as part of the permitting process for the 5 years previous to the date of the application. The TAC considers operating without required authorization to be a major violation. It's a major violation. To my earlier point, as part of TCEQ's evaluation of operators' compliance history, in its response to the comment, the agency related that this particular plant, this particular applicant is unclassified. All right, by TCEQ's own definition, an unclassified rating is generally given to new facilities without a history to rate. Ladies and gentlemen, this facility has a history. So that history should have been taken into consideration in making its determination. Clearly, it has a history that includes violations and investigations. I'd ask you to take a good hard look at that. OPEC disagrees with the Executive Director's decisions to deny reconsideration of the community, and also recommends an alternative that the Commission hold a hearing based on public interest. I would ask the Commission to also consider this. Under the initial agreed order, Texas Star Ready Mix was assessed a fine of $30,000. That was later increased to $35,000 when it was determined that the plant operated out of compliance for 3 months earlier than when first cited. Originally September the 12th, back to July the 23rd. Where did they get the information about it operating out of compliance? And then saying, got additional information about it operating out of compliance for 3 months prior to that. All that's a part of the record. ReadyMix did not agree to the initial $30,000 fine and would present to TCEQ an argument stating its inability to pay. Under the agreement, $31,400 of the $35,000 fine would be deferred based on its compliance. ReadyMix would only be fined $3,600 to be paid over 36 months at $100 a month. Now, this is a question that I ask you to consider. Is this how you normally handle these types of situations across the entire state of Texas? That will be a question I'm asking you to take into consideration here, and I'll be asking later on. It would seem as though that a applicant's history should in fact be taken into consideration. This application for concrete standard batch plant permit is to be granted prospectively. Texas Star ReadyMix is not allowed to reopen or operate until all the violations cited are remedied. Now, if the applicant presents that it cannot afford to pay $30,000 or $35,000 fine, where is it going to get the money to take care of the repairs that are necessary to come into compliance? The community has that question. I'll say, in closing, I support the opinions of the community, the EPA, and OPEC, that there are a number of questions remaining to be answered and other options to be explored. To the Joppa community and my fellow elected officials, the answer is that Texas ReadyMix application should be denied, and I support that particular position. And so members, I very seldom, if ever, I come before this particular body on issues. I've seen you over at the Capitol on different issues. But this is real important to my community, and making certain that this community and this applicant, who has a history that should be taken into consideration, that history is weighed based on the record in front of you before making a decision concerning this particular applicant. Thank you very much. I'll answer any questions that you have if appropriate. If someone is saying something, I cannot hear you.
And Senator, I was having difficulty with my mic. This is the chairman. I wanted to thank you again for joining us this morning. I wanted to thank you for your leadership and your public service and your comments here. We polled the other commissioners and we don't have any questions for you at this time. So thank you very much.
Thank you also.
colleagues, we don't always perhaps have the laws that we wish we had. We have to work with the laws that we do have. As you know, Section 382.058C of the Texas Clean Air Act states that only those persons residing within 440 yards of the proposed plant may request a hearing as a person who may be affected. None of the requesters reside within 440 yards, and so we're compelled to deny the hearing requests. Concerning the request for reconsideration from the association, I want to address a couple of the arguments that it raises. With respect to signage, there was a sign that was posted for approximately 150 days. The comment period was extended. Public participation was robust. It was not hindered, so I believe that the notice requirement has been satisfied. Concerning the enforcement agreed order, as was noted by the senator, it was not part of the compliance history, and that's because it was not part of the 5-year look-back period that we considered. Moreover, that order is on appeal, so even today, it is not part of the compliance history rating, which is how we judge the compliance of the applicant in permitting matters. So I am not seeing a basis for granting the request for reconsideration, and am interested in hearing your thoughts. Commissioner Janeka.
I'm in agreement.
I also agree, and especially with your sentiment that the law is not always the one that we would choose. I did dig in a little bit on the sign posting as well, because I wanted to make sure that there was some, robust public participation and that had been complied with. I just want to note the record indicates that those signs were posted at the site for substantially longer than that 30-day period, as you mentioned, more like 150 days. When evaluating public notice, legal standard is not perfect compliance, but substantial compliance. And we are looking at whether the notice has been approved by an applicant that complies with the essential requirements of the rule and does not hinder the purpose of imposing the rule. And that's why when the commission refers issues on compliance with public notice rules on applications, we use the phrase whether the applicant substantially complied with public notice. This was of such concern to me. I went back and also looked at where the commission had applied that same standard. I can note several agendas, April 12, 2024, February 7, 2024, February 21st, 2024, January 10th, 2024, May 10th, 2023, February 10th, 2021, March 31st, 2021, August 25th, 2021, it goes on and on. So the commission has a long history of applying that standard, and I thought that was important to raise with this community's concerns. So in this case, I do believe that they substantially complied with the notice provision.
It sounds like we're ready for a motion.
I move that we deny all hearing requests and the request for reconsideration, that we issue air quality standard permit for concrete batch plant registration number 171636 to Texas Star Ready Mix LLC as recommended by the executive director, and adopt the executive director's response to comments.
Second.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, I understand at the last agenda, there are some folks who were signed in to speak during the public comment item. And what I'd like to do, who were unable to do so, what I'd like to do is to move that item up next and take anybody who's either in the room or joining us online to offer public comments.
Okay, we do have some people online, I believe, and the commission will receive, we're calling item 23, calling it out of order. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permitting matters or other contested cases, which are the subject to the ex parte prohibition found in the government code. In the interest of time, speakers will be limited to 3 minutes each. with a total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and the recitation of existing policy. And with that, I'll begin with the folks who are online. I believe we have Mr. Errol Summerlin.
Mr. Summerlin, when you're ready, please just state your name and the floor is yours.
Yes, can you hear me?
We do, loud and clear. Thank you.
All right, thank you. Good morning. My name is Errol Summerlin, and I have a home in Portland. I'm also co-founder of CAPE, the Coastal Alliance to Protect Our Environment. Last month, I spoke about how this commission has enabled industrial development in the coastal bend and how industry takes advantage of your acquiescence and lacks permitting to ignore or otherwise manipulate the rules in total disregard for public health and the ecology of the coastal bend. Now we see ammonia facilities in Robstown and Ingleside. We see a desalination facility being built in a buffer zone created to protect a neighborhood from industry. We see a ground flare the size of a high school football stadium. We see perpetual flame that can be seen 20 miles away. We see dredging to accommodate more VLCCs, disrupting ferry traffic, commercial and recreational pursuits that make the coastal bend a livable, vibrant, but laid back home or destination. Now, while making public comment, we're asked not to make personal attacks on you or commission staff. That's a reasonable condition. However, it's a two-way street. Industry and this commission continue on a course that increasingly threatens local residents. When you locate a desal facility in a neighborhood, it gets personal. When you destroy Harbor Island, it gets personal. When you destroy seagrasses in La Quinta Channel, it gets personal. When you destroy a commercial and recreational economy, it gets personal. When a child suffers respiratory illness, it gets personal. When the windows in homes rattle from ground flaring operations, it gets personal. When properties are inundated by the wakes of increasing vessel traffic, it gets personal. When you have to put up dark shades on your windows to block out the light from a flare, it gets personal. When your eyes are tearing from the fumes and the pain in watching this transformation, it gets personal. It becomes more difficult to maintain civil discourse when our quality of life is under attack on so many levels. By ignoring our concerns, you make it personal. The biggest problem with the whole operation is the applicant and the TCEQ staff sit in their air-conditioned lab predicting air and water impacts of operations without ever thinking about the facility itself, how massive it might be, how it impacts a neighborhood or community. You don't even visit the site. You sit and look at a computer model. You've got to get out of the office, stand in someone's yard, and imagine a tower flare 500 feet high, years of construction equipment on your streets, and a sprawling 2 to 4 square mile landscape of concrete and steel. While we will try to maintain our composure and respect for this institution, as long as you sit in that office making life-changing decisions for us, the more personal it gets to us. Thank you very much for your time today, commissioners. We look forward to, and thank you for taking this extra opportunity to allow us to have public comment today, given the problems that arose on October 11th. Y'all have a great day.
Thank you, Mr. Summerlin, and sorry again for the difficulty you had at the last meeting, and we're glad you could join us and share your comments this morning. Thank you again, sir.
I think we have Kathy Fulton.
Ms. Fulton?
Yes, am I unmuted?
Yes, we can hear you. Go ahead.
Okay, thank you. Thank you. My name is Kathy Fulton and I live in Port Aransas, Texas. And I also want to thank y'all for putting the public comment on this meeting due to the technical problems of the last meeting. I am, again, some of the things that Errol Summerlin spoke of, I want to say that I fully agree with him. It's all become too personal. Everything going on has gotten personal. Listening to the previous discussion this morning, I heard a lot of personal things in that discussion. Now, what I want to say is that at one of the last meetings where I made comments concerning the my big concerns with TCEQs issuing of permits, even though the ALJs and the Office of Public Interest may recommend to deny a permit or to rework it, I'm not probably using the right term there, but to put in certain modifications. And yet we have seen several times this year, several times last year, at least for the Coastal Bend area, where those recommendations were ignored. And I think that the chairman had a bit of a response saying we follow what the courts say. Well, aren't the ALJs part of a court? They are, because I've been through 2 of these hearings. So it's a full-blown several weeks, and all you guys get is what is turned over to you on paper, maybe some audio, I really don't know. But I know that when we go through that and these judges are considering this very carefully because they're hearing everything, what you get are the summaries essentially. And I do not understand how you could sit here and say, oh, well, we follow what they say. No, you don't. You've rewritten them multiple times. In fact, a couple of times you've literally, I'm putting it bluntly, thrown out their decision and gone ahead and said, they got it wrong, we're issuing this. So I know that some of us are working on compiling a list of all these decisions, and hopefully we will have those prepared and ready to present, because there's quite a number. And what's even more interesting, there's quite a number that are all centered down here in the Coastal Bend. It seems like we're the ones getting the big bite from industry. And I just think you need to start. I agree. I wish at least one of you would try to attend a public comment meeting. That would be nice to see you there. Instead of other reps, one of you should at least show up and listen and hear what's being said. That at least shows you are somehow more aware and not just looking at paper. Thank you.
Thank you, Ms. Fulton.
And virtually, I believe we also have Charles Boone.
Mr. Boone, are you there?
Yes, thank you. My name is Charles Boone. I live at 468 Sunset, Ingleside on the Bay, Texas, San Patricio County. I'm the president of the board of directors of the Coastal Watch Association, which is an organization started about 5 years ago, largely originally because of the rise in sea level, but has turned due to the rapid industrialization in San Patricio County to turn to addressing that. Ingleside on the Bay happens to be located right at the junction of the Corpus Christi Ship Channel and the La Quinta Ship Channel. This access to the water has brought 60% of the petroleum shipped out of the United States within a mile of my house. A proposed ammonia plant with closer than that to my house. And I watched the impact here. I called yesterday to TCEQ because of an odor in the area. Well, of course, by the time any enforcement goes on, you've gotten a report from the industries who are self-monitoring, which seems like a rather inefficient way to monitor polluters. And then I watched you this morning making permitting decisions that by narrowly considering the permit rules, technical, legal information that you have. And what I noted was you don't really seem to respond, and I've been to many hearings too, you don't really seem to respond to the individual harm that's done, regardless of the law. So there's when the permitting is going on, when the plants are operating, when the particulate matter is coming off of the batch plant or off of the oil and gas stored right next to me. It's actually harming individual Texans. So individual Texans and their individual communities are being harmed on a daily basis. They see the degradation of air and water quality, and the commission doesn't seem to take and has a priority toward industrial growth rather than, even though it may come at the expense of Texans. I was prompted when I registered to put a question down. I have no idea why. It's the first time I've spoken here. The question I put is, what cost should individual Texans pay for economic growth? Should we pay the cost of death, chronic illness, moving out of my house, my property values dropping? I think that's a question that ought to be considered along with the technical legal issues that are being considered. Thank you for your time.
Thank you, Mr. Boone.
In person, we have Ms. Annie Spade.
Good morning, Ms. Spade. And you're a veteran with the microphone, I think. You do. The light, is the light on? Can you check that?
What do I do? I just push. There we go.
I think we've got you.
Okay. Good morning. My name is Annie Spade, and I live at 13508 Trail Driver here in Austin. I'm a fourth generation native Texan and former teacher with 5 young granddaughters living nearby. I am also connected to a number of environmental groups and initiatives, including the Coastal Coalition CAPE, which you've heard from this morning. I've camped on North Padre Island National Seashore for decades, so I'm very familiar with the area. I manage my 1.5 acres in northern Hayes County here as a pocket prairie. And for over 30 years, I've been amazed to see how beautifully the land can thrive with native grasses and forbs, attracting many kinds of birds and other animals. Though we've seen some very dry times over the years, the landscape has always recovered easily. But today I find it's different. Not only have we had rainfall far below average, but the temperatures have consistently been 5 to 10 degrees above normal month after month, year after year. Since we're on a well, we have a true xeriscape and cannot water. And our native drought-tolerant plants and wildlife are struggling like never before. Desertification seems to be well on a way, and companies are canceling or doubling homeowners' insurance in my area due to the ever more certain danger of fire. Last month, I urged you to take a broader view of the projects you're reviewing, including the long-term effects of projects into the next century, which will be the legacy we leave to today's children. This includes the carbon emissions, which fuel this global warming. Recently, I realized that the 3 of you are never present for the many local and well-attended TCEQ meetings in communities all over Texas. Even the executive director who directly advises you is not in attendance. This is a very great tragedy, I feel, because it isolates and handicaps you in your critical decision-making commission. For example, you might see and hear from citizens living only a mile from a proposed ammonia plant, as you did a bit this morning, with an elementary school in the same area and no easy means of escape in case of a leak disaster. Or from another community telling of the pristine waters of Barton Creek, where families have swam for generations and which may soon be sullied by the first effluent ever, simply to accommodate a music venue. I believe it behooves you in your position, Commission, to attend at least a few of these meetings, to hear more personal stories like these, and to sense the ardor and angst of our neighbors begging your help in protecting their health and the beauty of our fair state. Thank you again for your kind attention to my brief remarks today. I hope to see you again next month.
We look forward to it. Thank you, Ms. Spade. Appreciate you being here. Ms. Smith, is there anybody else signed in to speak?
Nobody is currently signed in to speak.
Okay, I think that takes us back to item 1, if you want to call that caption.
Give everybody a moment to make their way up. Item number 1 is the consideration of whether to affirm, modify, or set aside the executive director's emergency order renewal, appointing a temporary manager of a water utility abandoned by Linda Royal, Robert Watts, Peggy Parlin, Mitchell Watts, and Shane Watts. The ED is the moving party and should speak first, followed by the respondents who are not signed in or registered at all. The temporary manager may also speak, but again, the temporary manager is currently not registered or here. And any other interested persons, again, currently none. Followed by OPIC, who is here. And that would be the order. OGC recommends 5 minutes for each party, and the ED may save time for rebuttal as the ED bears the burden of proof on this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. My name is Benjamin Warms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Kristen Hernandez with the Water Supply Division, and we're joined online by Joy Thurston Cook with the San Antonio Regional Office. Item number 1 concerns the emergency order appointing a temporary manager for a utility formerly owned by Alan Watts. This utility was owned by Alan Watts from 1997 until his passing in October 2021. Mr. Watts died intestate without transferring ownership of the utility, and his estate has not been probated. Accordingly, the named respondents in this emergency order are the children of Alan Watts, who are the known heirs to the estate of Alan Watts under Texas intestate succession. At the time of Mr. Watts' death, the utility was being operated by Paul and Linda Royal. On August 1st, 2022, the Royals sent a letter to staff of TCEQ, the Public Utility Commission, and the Office of the Attorney General, stating that they would stop operating the utility on September 1st of 2022. Given this notice from the Royals, TCEQ determined the utility was abandoned and created a substantial risk of imminent water outages and posed health hazards to the customers of the utility. At the time, the City of Luling agreed to step in to assist in operating the utility. The executive director issued an emergency order on September 1st of 2022, appointing the City of Luling's wastewater operator, Bill Shuley, to be a temporary manager for the utility. TCEQ renewed Mr. Shuley's appointment on March 1st, 2023, and under subsequent circumstances, later appointed as a temporary manager the City of Luling's water superintendent, Mr. Jaime Ovalle Sr. Throughout 2024, TCEQ staff worked with the City of Luling to explore long-term solutions for the utility's abandonment and to place the utility into receivership. Staff worked to facilitate funding through the Supplemental Environmental Project Program and to explore other funding sources throughout the state with the goal of enabling the City of Luling to interconnect the utility with the city's own distribution system. However, on July 11th, 2024, the Luling City Council voted to forego a receivership agreement and not let the temporary manager appointment continue past Mr. Avalle's term, which ended on August 26, 2024. Without appointment of another temporary manager, control of the utility would revert back to the owners named in this order, who have already abandoned the utility in 2022 and not shown any interest since that time. To avoid this utility returning to abandonment, the executive director issued this emergency order appointing Ochoa Operations LLC to serve as a new temporary manager for the utility. This appointment and order were needed to ensure continued operation of the utility and to allow time for renewed efforts to arrange for an appointment of a receiver. Even under the current temporary management, problems at this utility do persist and reoccur. Since the executive director issued this emergency order, our San Antonio regional office has received one complaint and reports of water outages due to the utility's age and poor condition. Nevertheless, the temporary manager has worked to fix the current water outages at the utility, and TCEQ staff are coordinating to address issues with this system and working towards a long-term solution. These efforts include providing available resources and continuing the search for funding that could enable a stabilizing and permanent solution for the customers of this utility. The executive director respectfully requests that you affirm the September 5th, 2024 emergency order because it remains the most appropriate response to the needs of the community served by this utility. We are available to answer any questions you may have, and I will reserve the remainder of my time.
Thank you, Mr. Worms. I have none. Any questions, colleagues? Seeing none, no respondents have signed in, nor has the temporary manager, nor have any interested persons. So we'll go to OPIC and Mr. Wayne. Good morning.
Yes, thank you. Good morning, Chairman, Commissioners, General Counsel, and the Executive Director's attorney and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. OPIC has reviewed this item and agrees with the Executive Director that requirements for an emergency order contained in Chapters 5 and 13 of the Texas Water Code have been met, and renewal of this emergency order was necessary and appropriate. As such, we support affirmation. We observe that this is the fourth emergency order issued in this matter. Unfortunately, we must recognize that significant impediments to a long-term management solution for the utility have presented themselves, necessitating this emergency order. It appears that an interconnection project involving the city of Luling has been abandoned, which is certainly a step back. That is not, however, to discount the hard work of TCEQ staff, and specifically our SEP staff, who work to support this project. All this to say that we remain optimistic a resolution will be reached and a permanent operator will be found to operate the utility. We note that the utility has been referred to the Office of the Attorney General for appointment of a receiver, and our understanding is that these efforts are ongoing. Finally, we want to express our appreciation for Ochoa Operations LLC for stepping up and temporarily managing the utility. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Colleagues, any questions? All right. Well, colleagues, for the reasons that we just heard from Executive Director staff and Mr. Wayne, pending your thoughts, I would issue this order.
I'm in agreement.
I'm in agreement. Would you like a motion? I move that we affirm the Executive Director's emergency order renewal appointing a temporary manager of the water utility located at 114 Salt Lake Road, Luling, Guadalupe County, and issue the Executive Director's proposed commission order.
I second the order.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
That brings us to item number 2, which is the consideration of an application by Corpus Christi Polymers LLC for renewal of TIPD's permit number WQ 000-501-9000. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I'm going to leave this item in your capable hands and recuse myself from it.
For this item, we are reviewing Corpus Christi Polymers LLC's application to renew its TIPD's permit to authorize the discharge of its commingled wastewater streams from the Corpus Christi Polymers plant. Here, I agree with the Executive Director and OPIC that there is no right to a hearing on this matter. First, the applicant does not seek to increase the quantity of the waste to be discharged or change the pattern or place of discharge. Second, the applicant's renewal permit with the enhancements made by the Executive Director improve the quality of wastewater authorized to be discharged. Third, notice was provided to the public of their opportunity to request a public meeting, and a public meeting was held. Fourth, the Executive Director filed a response to all timely received comments. And lastly, a review of the applicant's compliance history does not raise an issue regarding its ability to comply with the material term of the permit. And based on Texas Water Code, Chapter 26.028D and 30 Texas Administrative Code, Section 55.201I5, I would find that there is no right to a hearing in this matter. I don't believe that it's appropriate to grant a hearing in the public interest in this matter. I would also deny the requests for reconsideration, since I do not believe that they bring up new, relevant, and material information for the commission to consider. Given this, I would issue the renewal of Corpus Christi Polymers LLC's TIPD's permit as recommended by the executive director and adopt the ED's response to comments. What are your thoughts, Commissioner Gonzalez?
I agree.
I will, I don't think we need any more discussion. Already hear from parties. I would move that we find there is no right to a hearing on this application pursuant to Texas Water Code, Section 26.028D and 30 Texas Administrative Code, Section 55.201I5. I further move that we deny all hearing requests and requests for reconsideration. Move that we issue the renewal of TIPD's permit number WQ000501900 to Corpus Christi Polymers LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
Second.
All those in favor, say aye.
Aye.
Hearing passes. Thank you, Ms. Smith. I'll let you call the next item.
Item number 4 is the consideration of an application by Circle S Midlothian LLC for new TIPD's permit number WQ00162430001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, this is not a particularly large discharge at less than 1 million gallons per day. Given that and the nature of the discharge, I don't see how the Osro Road requesters, who are located nearly 3 miles from the proposed facility, would be affected in a manner different from the general public. And Ms. Taylor's request does not identify a personal concern or specify really any concern, so it provides us no basis to grant a hearing. So I believe we need to deny these requests. Ellis County, however, has demonstrated affected party status, including articulating its legal authority and interest in assessing water quality and in enforcing water code violations. The county also articulated relevant and material issues, including whether water quality is protected, policies around regionalization and need, compliance history, notice, and the completeness and accuracy of the application. So I would refer the county's request on those issues. Commissioner Janeka.
I'm in agreement.
Also in agreement.
I believe we're ready for a motion.
I move that we grant the hearing request of Ellis County, deny the remaining hearing requests, refer the application to SOA for a contested case hearing on the following issues: whether the draft permit is protective of water quality and the existing uses in the receiving waters under applicable rules, including the Texas Surface Water Quality Standards and 30 Texas Administrative Code, Chapter 307, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need and the general policy to promote regional or area-wide wastewater systems under Texas Water Code Sections 26.0282 and 26.081, whether the draft permit should be altered or denied based on the applicant's compliance history, whether the application is accurate and complete, whether the applicant substantially complied with applicable public notice requirements, and I would set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of the nomination and appointment of one person to the Tax Relief for Pollution Control Property Advisory Committee. The Executive Director's staff is here to present this item.
Good morning. The microphone might not be turned on. Yeah, we can hear you, but
Thank you.
not everyone can.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Melissa Altman with the Air Quality Division. With me is Don Redmond with the Environmental Law Division. As described in Section 1131 of the Texas Tax Code, TCEQ is required to establish a permanent advisory committee to advise the Commission regarding the implementation of the Tax Relief for Pollution Control Property Program. An appraisal district representative position is available because one of the members whose term expired on December 31st, 2025, resigned his position effective January 8, 2024. Notice of the vacancy was posted in the Texas Register and on the TCEQ website to solicit applications. The submitted applications and the executive director's recommendation for appointment to the vacant position are presented today for your consideration. We thank you for your consideration of this matter and are available to answer any questions.
Thank you, Ms. Altman. I have none. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No one is signed in on this item.
Mr. Arthur, what does OPIC think?
Good morning, Chairman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of the proposed resolution.
Thank you. Colleagues, I do too. I appreciate all the nominees' willingness to serve, and I'm ready to move forward with staff's recommended appointment.
I move that we adopt the proposed resolution appointing Josh Badowski to the Tax Relief for Pollution Control Property Advisory Committee as a representative for appraisal districts to complete the remaining term of Roland Bieber set to expire on December 31st, 2025.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
That takes us to the enforcement docket, which are items 6 through 20. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 6 through 20. The total assessed administrative penalties are $196,605, with $22,071 deferred, $29,350 applied towards supplemental environmental projects, and $145,184 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions? No. Seeing none, has anybody signed in to speak?
On item 8, we had John Cody Neef registered. Is Mr. Neef here in the audience? He's not currently signed into the webinar.
We had received communication that he was trying to get in.
Okay.
Mr. Neef, are you with us virtually? All right, well, let's come back. Was there anybody else signed in wishing to speak?
No one else is signed in.
Okay. Mr. Arthur, what do you think of this docket?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
All right, thank you. Colleagues, let's do this. Let's continue this docket, these items, move on to the monthly enforcement report, take care of that and come back and see if we can pick up Mr. Nee's comments. And Ms. Sedemeyer, I think you're up. Good morning.
So I'll call item 21, which is consideration of the monthly enforcement report.
Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through August. There were 1,083 effective administrative orders issued, and of those, 189 contained supplemental environmental projects. These orders assessed a total of $18,865,348 with a payable amount of $9,522,697. $7,057,712 are to be paid towards supplemental environmental projects. 15,235 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 2,064 enforcement action referrals have been received. There are 3,085 pending administrative orders with 1,523 cases that are on the backlog. This number does represent a slight increase from last month's report. While this increase occurred due to the division managing departures of critical staff, as well as overall end-of-year priorities, I want to acknowledge the increase and inform the Commission that the division immediately took steps to make adjustments, and we are seeing a decline again in our overall numbers, which we will report on in upcoming meetings. 136 cases are pending at the Attorney General's office for representation in district court, and 14 judgments have been issued. 1,334 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Ms. Sedemeyer. I have none. Any questions, colleagues? Seeing none. Ms. Smith, is anybody signed in to speak?
No one is signed in on this one.
Mr. Arthur?
LPIC has no comment except to say that we appreciate staff's report.
I appreciate the report. I appreciate the explanation, and no action is necessary on this item. So let's check in with Mr. Neef. Have you been able to join us, sir?
I believe he has, so we'll return to enforcement items 6 through 20.
Okay. Do you need to call that caption again, or?
Let's
nah?
consider that done.
All right, good. Mr. Neef, when you're ready. I'm sorry, say that again, sir.
Can y'all hear me?
We can. Go
You
ahead.
guys hear me now? Perfect. Sorry.
We hear you. Yes, sir. Go ahead when you're ready.
Yeah, John Cody Neef. I'm the Vice President of Affordable Storage. First time I've had to deal with this. And so where we were at is we submitted a contributing zone plan for a property that we purchased. It was a storage facility that was already in existence. And when we purchased it, we added 3 more buildings, and we submitted a contributing zone plan for the area we were going to be disturbing, and we were denied that because we were told that we had to account for all the other buildings that were previously built before we owned the property, and we just cannot financially do that. So.
Okay, is that the extent of your comments, Mr. Neef?
That's it, and I just don't know the process of any type of variance that we could request or how that needs to work.
Well, what's before us this morning is an enforcement order, and that's an agreed order. And I think in terms of remedies outside what's before the commission today, that's going to be a separate matter. What I could suggest is that you touch base with our Office of Public Interest Counsel. They can point you to some resources that may be helpful. We also have a team with the regional office that assists small businesses and local governments. They can provide compliance counseling and point you towards resources which may be helpful to you. So start in either of those 2 places.
What, and can you list that again? I'm trying to write it down.
Sure. One is the Office of Public Interest Counsel.
Okay.
Mr. Arthur, I'm going to impose on you and ask you to read a phone number.
Certainly, Chairman. Good morning, sir. You can contact me at 512-239-5757.
Perfect. Thank you very much.
Thank you, sir. We appreciate you calling in this morning and sharing your concerns with us.
Yes, sir. Thank y'all.
Thank you. All right. I think we're done with the enforcement docket 6 through 24 in terms of hearing from all interested parties.
That's correct. He was the only person signed in to.
Okay. Colleagues, any other comments on the enforcement docket? I'm ready to move forward with it.
I move that we adopt items 6 through 20 as recommended today by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, when you're ready, please call item 22.
I'll give people a moment to switch spots. Item 22 is the adoption of the addition of new sections for amendments to and the repeal of certain sections within 30 Texas Administrative Code, Chapter 281, Chapter 328, Chapter 330, and Chapter 335. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me is Diane Goss with the Environmental Law Division. This adopted rulemaking would implement House Bill 3060 relating to the conversion of plastics and other recyclable material through advanced recycling technologies and implement Senate Bill 1397 relating to the requirement for an electronic copy of a permit application from the 88th Texas Legislature 2023. The proposed rulemaking, the adopted rulemaking would also repeal 3 rules determined to be obsolete, make minor programmatic updates, and revise incorrect rule citations or references. The proposed rules were published in the May 24th, 2024 issue of the Texas Register. A public hearing was held on June 20th, 2024. And the public comment period closed on June 25th, 2024. No public comments were received. In conclusion, staff respectfully recommends adoption of the rulemaking to Chapter 281, Chapter 328, Chapter 330, and Chapter 335. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Sepulvedo. I have none. Any questions, colleagues? Ms. Smith, has anybody signed in to speak?
No one has signed in on this item.
Mr. Arthur, what's the view from OPIC?
OPIC reviewed this rulemaking, which implements HB 3060 and SB 1397 by making conforming changes to 30 TAC, Chapters 281, 328, 330, and 335, and also repeals 3 rules determined to be obsolete in the Chapter 281 quadrennial rule review. The rulemaking is legislatively required, and the change to 30 THC Section 281.5 regarding electronic posting of permit applications will benefit the public by making applications more accessible. We note that no public comments were received despite robust public participation efforts, and no reasonable alternatives exist to implement the mandates of SB 1397 and HB 3060. Additionally, retention of incorrect citations in the waste rules could create confusion for rule users and perpetuate regulatory inconsistencies and gaps. For these reasons, OPIC supports adoption.
Thank you, Mr. Arthur. Colleagues, as we just heard, this is a pretty straightforward piece of legislative implementation and cleanup. There were no comments. I'm ready to move forward.
I move that we adopt the amendments to repeal of and new sections within 30 Texas Administrative Code Chapters 281, 328, 330, and 335, as recommended by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, let's come back to the public comment session. If there's anybody registered to speak, I just wanted to make sure we didn't leave anybody hanging.
There's no one registered. We got everybody who was registered earlier in the meeting.
All right, great. Well, before we adjourn, we have a little bit of TCQ family business to tend to. Guy Henry is retiring after 32 years of service with the agency. It's incredible. For the last 20 years or so, Guy has served the agency as senior attorney in the Environmental Law Division's Waste Section. And among his many accomplishments, he's overseen the legal work at numerous complex environmental cleanups at contaminated sites across the state. He's reduced the risk to public health, and he's improved the environment in communities across Texas. In my view, Guy's greatest accomplishment, however, is the legacy that he leaves as a leader of this agency, and that's a legacy of service. Guy is both an outstanding public servant and a servant to his TCEQ colleagues. He embodies that pillar of TCEQ's culture, demonstrating that no matter what position you occupy on the org chart, your obligations emanate outward, up and down, and across the agency. We help each other, we support each other, and we serve each other. And that is Guy. And I would emphasize that those obligations are really greatest for our leaders. As a leader, here's what Guy's staff has to say about him. And it reflects the tribute that I just offered, that he managed the waste section as a team with an all hands on deck attitude, where staff attorneys are mentored, supported, and allowed to shine. His staff notes that he is respected inside and outside the agency as someone who will always pick up the phone, is willing to listen and provide advice. He's known for imparting knowledge. He's a good friend and a steady, calm influence. And his staff describes him as someone who's always willing to roll up his sleeves, dig into the law, do the work that's necessary to provide the high level of services that his client representatives and the public expect and deserve. High praise indeed, and particularly meaningful coming from your staff. So Guy, thank you for everything you've done for this agency and this state. And more than that, thank you for being a model of how to do it. We really appreciate your service and wish you the best in your next chapter. Two more things. If you have any comments you'd like to offer, we would love to hear them. And I guess the podium is a good spot. And also I've got some goodies for you when you're done.
Thank you very much, Chairman. That was for very kind words. I couldn't be here and be in this position without, of course, my wonderful friends, coworkers, the agency staff members that I've known for so many years. Because the agency's been a huge part of my life. And that's what I care about, is trying to take care of our state. And I hope to continue doing that in the future. So just finding my way. But again, thank you all very much.
Thank you, Guy. Stay put. I've got some things you can drag home with you.
While the chairman's relocating, I'll seize the microphone and just add that my prior time in the staff ranks at this agency, the whole time I've been here, all the hard questions always flowed across Guy's desk in some way. So I really am going to just second all those kind words from the chairman.
All right, this is like Christmas. I believe this is a flag that was flown over the Capitol. This is the certificate that says, indeed, the flag was flown over the Capitol. And then I have a proclamation from the governor's office that I'd like to read. And it states, "Greetings to Guy Henry, Texas Commission on Environmental Quality. As governor of Texas, I'm proud to offer congratulations as you begin your well-deserved retirement. At the very heart of the Texas spirit lies an abiding desire to serve our fellow man, and state employees exemplify this ethos by serving their fellow Texans. After 31 years of dedicated service to the people of Texas, your remarkable career draws to a close, and there can be no doubt that the state of Texas is better off for your efforts. Although the sheer scope of your career is vast, it pales in comparison to the impacts you have made on the individual lives and the example you have set for your loved ones. Public service is both a noble calling and a profound honor. Boy, I'm really feeling this. It is rooted in the public trust. You have proven yourself worthy of the trust of Texans, the trust that they have bestowed on you, and your legacy will echo throughout the ages long. On this special occasion and hereafter, First Lady Cecilia Abbott and I wish you and yours all the best. Sincerely, Greg Abbott.
Very nice. Thank you. Here's a bag. Oh, yes, yeah.
All right.
Thank you all very much.
Yeah. Do you want to
Hey,
close
Guy.
the agenda first, or do you want to?
Yeah.
Yeah.
Don't go far. We want to take a photo.
So items 24 through 27 are the only remaining items, and those are for closed session, but the commission is not meeting in closed session.
Okay. Terrific. In that case, the time is 10:46 and we are adjourned. All right, Guy, don't go anywhere. We want to take our picture with you.